Good evening to everyone. On behalf of Sathe College Political Science Department and NSS, I welcome you all for this special program on the occasion of Constitution Day. We are having a special guest today, Dr. Ananta Kalse sir, who is going to address us on the Indian Constitution, its ethos and its values. Uh, since there are many students, I would like to tell you the importance of the Constitution Day in very brief manner. On 26 November 1949, the Constitution of India is adopted, enacted, and according to the preamble, it is given to ourselves, that means to the Indian citizens. And you may be aware that the Indian Constitution is one of the biggest written constitution in the world, and it is one of the most beautiful gift the Indians have given to the world. But the Constitution and its writings will become just mere dead letters if we do not imbibe the spirit of Constitution and implement it properly. Therefore, it is needed to create the awareness regarding the Constitution spirit, constitutional values, and constitutional ethos. It is our national duty to uphold the Indian Constitution. And this is the reason why our college, as every year, is celebrating the Constitution Day and try to create the awareness among the students and the fellow attendants. So on this occasion, I welcome you all again, and I request our Honorable Principal, Dr. Madhav Rajwade sir, to address the gathering and later on to read the preamble of the Indian Constitution. Over to you, sir.
Thank you, Ketan sir and Ketan Bhosle sir. It is indeed every citizen's duty to observe today's day and do it with a lot of pride, as very ably pointed out by Ketan Bhosle sir, that this is a gift to the world by our country, our beloved country, India. On behalf of our college, Sathe College, I welcome our today's speaker, Dr. Anant Kalse sir. He very, I should say, gracefully accepted our invitation and has agreed to enlighten our students regarding this particular important topic. At an early stage, they should be exposed to these values, this knowledge, so that later they become a real responsible citizen of our country. Also, I must thank at the outset the Department of Political Science and NSS for having taken initiative in this direction. Okay, so HOD Veena Khandolkar madam, indeed it's a good effort to get one of the recognized speakers in this particular arena. For our college, this has been a tradition to observe Constitution Day most fervently, and the participation of teachers, students, and all other stakeholders is alike, and it is done with a lot of enthusiasm. With these words, I will read out the preamble of the Constitution just to make students aware about what the document is all about. More, of course, light will be thrown by our honorable speaker today, Dr. Kalse sir. So all of you, please pay attention to the words which have been written by the constitution makers way back when the constitution was made in 1949. All right. So it goes like this. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. This was done, it is said, the date is also written in our Constituent Assembly. this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So, dear students, this is a very important document, and today we are fortunate to have Dr. Kalse amongst us. I'm sure we need to be introduced to him formally. That will be done. Thereafter, we will be listening to him. So, over to you, Ketan. Thank you. Ketan, you are muted.
Sorry. Thank you very much, Dr. Rajwade sir, for highlighting the importance of the Constitution as well as reading out the preamble for all of us. I'm sure the student will learn more about it in the upcoming lecture. This is my indeed a privilege to introduce our today's guest speaker, Dr. Ananta Kalse sir. Since the students are there, I just read out his education qualification. He has done BSc, then LLM and PhD in law from Mumbai University. He retired as a former principal secretary of Maharashtra Legislative Secretariat, and he has also worked as the secretary of Commonwealth Parliamentary Association of Maharashtra branch. He is a passionate teacher because he is associated with the number of institutions. In fact, I have a list of the institution, and all of them are reputed institution where he is a visiting faculty and teaching law to the students. He has actually started his career as an advocate in the district and the session court of Aurangabad, and from 2007 he has shouldered the responsibility of a principal secretary of Maharashtra Legislative Secretariat. He has written a lot of research paper, visited conferences, national as well as international, and a very we can say uh, a, a perfect person to talk about the Constitution on the occasion of the Constitution Day. So again, I welcome Dr. Ananta Kalse sir to our college on this Zoom online platform on the occasion of the Constitution Day, and we are very much eager to listen to you. Uh, so I request you to kindly begin your talk. Thank you, sir. So you're muted.
Hello.
Would you listen me, sir?
Yes, sir.
You are audible, sir.
Yes, sir. Yes, sir. You are
I'm
audible.
audible?
Yes,
Okay.
sir.
Okay.
Yeah.
Thank you. Good evening to all. Respected Dr. Madhavrao Rajwade, sir, principal of this college, reputed college. Dr. Nerkar, vice principal. Srimati P.M. Sawant, vice principal. Sri Vinod Gaware, assistant vice region coordinator, NSS. Sri D.D. Bombay, sir, NSS program officer. Sri Kosambi, sir, NSS program officer. Srimati Swati Jagtap, Madam, NSS Program Officer. Srimati Vaishali, Madam, NSS Program Officer. Sri Anil Manze, NSS Program Officer. Srimati Beena Khanolkar, Sir, HOD, Department of Political Science. Ketan Bhosle, Sir, and all the above, my good friend who is managing all technical matters in Legislature Secretariat, Ajay Sarvankar, Sir. Today, I am very much thankful to Sathe College, which is a very reputed college in the university and in the Mumbai prestigious college, who is imparting quality education in this field from so many years. And I am really very lucky to be here to express my views, share my views before the invitees, dignitaries, all my dear students for this Constitution Day. First of all, at the outset, I give my best wishes for the Constitution Day. Under the able stewardship of Honorable Principal Dr. Rajwade sir, college is progressing lot and achieve a fame in the city of Mumbai. And it is really my pleasure and honor to be amongst yourself. I congratulate to all for achieving this excellence. I am thankful to all for inviting me here. So far as this Constitution Day is concerned, everybody knows that previously it was celebrated as a law day. But from 2015, a union cabinet under the stewardship of Prime Minister, they have taken a conscious decision to celebrate 26th day of November 26th, that is Constitution Day, because on that day the Constitution was adopted. As rightly this preamble was recited, we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual, unity and integrity of the nation. And in our Constituent Assembly, this 26th day of November 1949, to adopt, enact, give to ourselves this Constitution. This day is very important because on this day, this Constitution was adopted. And the complete edifice of the Constitution is based on the four most important principles: sovereign, socialist, secular, democratic, republic, and justice, liberty, equality, and fraternity. These are the four pillars on this Constitution is based. Complete ethos and characters and values of the Constitution you will get in the preamble. My earnest request on this Constitution Day is that you made a constitution that is your way of life. The principles laid down in the Constitution should be a way of life, and really it is a duty on this Constitution Day, as Dr. Principal Sir has pointed out, that it is a you must achieve, strive, and protect the principles and Constitution and democracy. It must be aim and goal of your life. So this is my earnest request to all my young friends. How the Constitution is made? I just give you a brief idea about the making of the Constitution. It is a very lengthy document, as just pointed out. Originally, this Constitution has 295, 395 articles and 8 schedules. But how this is made, a Constitution? Because it was drafted by the Constituent Assembly. The members of the Constituent Assembly, they are very renowned persons like Pandit Jawaharlal Nehru, Sardar Vallabhbhai Patel, Dr. Ambedkar, Alladi Krishna Swamy Iyer, Dr. K.M. Munshi, then Gopal Swamy Iyengar. A lot of by Barrister Jayakar, total 293 members of the Constituent Assembly. They have just eminent personality of this country, those who are aware of the political, legal, and administrative and social situation of this country. And they have studied hard for preparing this Constitution. Not only that, they have studied the Australian Constitution, New Zealand, America, Britain, all these major constitutions, those that time existed, that they have studied. And this unique document contains the best features of all the documents, because we have taken all these system, democratic system, that is a parliamentary system of the government. We have inherited from the British parliamentary system, federal nature of the Constitution from the America and Canada. That is a inter-union state relationship from the Australian Constitution. So all best features of other constitutions are gathered, because our constitutional makers, they have gathered the best feature of the Constitution, those that time existed, and they have included, incorporated in this unique document, which is suitable to this country. The Constituent Assembly debates, 12 volumes are there. it is really interested to just go through the Constituent Assembly rules, Constituent Assembly debate, and particularly the the resolution passed by Pandit Jawaharlal Nehru, that is which is called a objective resolution, that is form the basis of the preamble and basis for framing of the constitution. Particularly, the preamble is based on the objective resolution passed in the Constituent Assembly, whose first meeting was held on the 9th of December 1946. Dr. Rajendra Prasad was chairman of the Constituent Assembly, which was held in the Central Hall of the Delhi. Now, that time it is called a Constitution Hall. Drafting committee later on, after this Constitution, Constituent Assembly has taken 2 years, 11 months, and 17 days for drafting this huge document, which contains the government of the state also, government of the union also, which is called language provision, that is a recruitment provision, public service commission, that is a language for the courts, high court, supreme court, directive principle, fundamental rights. Each and every, that is a chapter, each and every part of the administration, they are included in the constitution. Because that time our constitutional maker felt that if we were failed to include all these parts in the constitution itself, this unique document or this infant democracy might be jeopardized, and infant democracy might be destroyed. That's why they have tried to include each and every part of the administration in this document, unique document, and this document become a comparatively bulky one, because you see the American Constitution of 1787, only 7 articles are there, and last 10 amendments including the fundamental rights. Australian Constitution, 139 articles. New Zealand, Switzerland, very, very small one compared to our document. But our constitutional makers, forefathers, the members of the Constituent Assembly, they thought that all the matter of administration must part, then only this country will progress, and then only this country's administration runs in a better manner. And that's why we are celebrating this that is a Constitution Day, to protect and to inculcate the ethos, characters, salient feature of this Constitution in the minds of the citizen of India, particularly the Constituent Assembly. How it is the process is started. Briefly, I'll explain. After Second World War, that Lord Atterley, Winston Churchill, is deadly against the giving independence to the India. But after Second World War, Lord Atterley becomes the Prime Minister of the England, and he decided to give independence to the British colony, that the India, those days British colony, and they have constituted the cabinet mission. Cabinet mission under the leadership of the 3 British cabinet ministers, Lord Patrick Lawrence, Sir Stafford Cripps, Mr. Alexander. They have visited India and they have discussed with the leaders of the India, and ultimately the Constituent Assembly was established. And Constituent Assembly, the structure is based on the indirect election. The 297 members from the provinces, and 93 members from the princely state. Anywhere, I will not go much deep. But Constituent Assembly, which is a body, which is a main body who is responsible to draft the constitution. That on first meeting of this assembly was 9th of December 1946. First sitting of it, Dr. Rajendra Prasad was chairman of the Constitution Assembly, and ultimately the drafting committee, after considering the draft of the constitution, the drafting committee was established on the 29th August 1947. Very eminent members were the members of the drafting the committee. Particularly, Dr. Ambedkar was the chairman of the drafting committee, N. Gopal Swami Iyengar, Dr. K. M. Munshi, Alladi Krishnaswamy Iyer, that is Krishnamachari, Sayyid Sadullah, and Madhavrao. They have rigorously pursued the best provisions of the world constitutions, and they have studied all those things and included the provisions suitable to our country in this document and Constituent Assembly, and this document was prepared in 2 years, 11 months and 17 days. And that is the three historic speeches of Dr. Ambedkar on whose birth anniversary this Constitution Day we are celebrating, and Union Cabinet has taken decision to celebrate the Constitution Day, that is on 26th day of November 1949. We have adopted the Constitution, and this day we are now celebrating as a Constitution Day. That is 17th December 1946, 4th of November 1948, and 25th November 1949. These are the three important speeches Dr. Ambedkar has made in the Constituent Assembly, in which his famous speech, however good Constitution may be, everybody has to remember this speech. However good Constitution may be, but it is surely turn out to be a bad, because those who are called to work it happen to be a bad. But however bad Constitution may be, it may turn out to be a good if those who are called upon to work it happens to be a good law. It is a famous statement made by Dr. Ambedkar in last lecture, 25th November 1949. So that's why the person, those who are chosen to run the country, to run the administration, must be of good caliber, good character, morality, and with integrity. Then only this constitution works, this country runs on the efficient basis, and in that way, this constitution that prepared, and in fact, on 26th day of November 1949, the Constituent Assembly gave this document and became a functioning official. Of course, on 26th Jan 1950, this document came into force and India became the Republic India, and 1952 elections were held. What is the characters and ethos of the Constitution? First of all, I will go to the rule of law. Rule of law is a very crucial characteristic of our Constitution, Indian Constitution. What do we mean by the rule of law? We are governed by the rule of law. We are governed by the law, not by man, not by any arbitrary action of any king, arbitrary actions of any elected government. But we have been governed by the rule of, that is a law, and that law is not an arbitrary law, but law is a just, fair, and reasonable, based on the principle of the natural justice. So everybody, my earnest request is that if somebody asks you who is governed, you have been governed by the rule of law. Very important principles the Constitution gave us, that is the rule of law. Rule of law, it is a very ancient concept developed in the Britain, because it is devised by the Blackstone, very famous, that is a constitutional scientist. But scientifically, Professor A.V. Dicey, who has developed this concept while delivering lectures at the Oxford University in the year 1885. So he defined the concept of the rule of law in three parts: supremacy of law, equality before law, and predominance of the legal spirit. In that way, he has defined the principle of the rule of law. And rule of law is the ethos and characteristics of the Constitution, most important ethos and characteristics of this Constitution. And on this Constitution Day, you have to study the concept of the rule of law. What is that? Is the supremacy of law. Supremacy of law is supreme. Nobody is supreme before the law. Law is applicable to all persons. There is no arbitrary power, capricious power, no nepotism, no discretionary powers. Dicey specifically ruled that we have been governed, English peoples were governed by the law and law alone. They were punished, they were by the breach of the law only, nothing else. So that is a very important concept of that supremacy of law is developed in the form of the rule of law. And that all concept of the rule of law, it is ingrained in our Constitution. I will come to that point. Then second principle is equality before law. There is no difference between ordinary law. There is no that is arbitrary powers. Equality, all are equal before the law. If anybody has to commit any offense, then they are tried by the same court, same metropolitan court, same civil court, same criminal court, punished by the same, that is a judge. There is no difference, discrimination. Everybody is equal before the law. That is Article 14, 15, 21. These are the principles laid down in the Constitution itself. Then predominance of legal spirit. So all these rights which has been included in the Constitution, people's rights, are protected by the code. Of course, this is a concept of evidence, but a very important concept of rule of law. It is a gift from the British Constitutional System. And on this basis of the rule of law, now we have been governed by the principle of the rule of law, and now the rule of law became part of the integral part of our Constitution. Article 14, Article 21, Article, that is 19, Article 32, Article 13. These are all articles based on the principles of the rule of law. So rule of law, it is a first concept, which is very important concept, ingrained, included in the Constitution. That's why our complete system of administration is run on the basis of the rule of law, on the principle of the rule of law. In that way, I earnestly request all my dear students, please study the Magna Carta, 1215. It is a charter of liberty. King John has given some certain rights, liberty, equality to the British people. In that way, Magna Carta. Then first, 5th and 14th Amendment of the American Constitution, 1787's American Constitution. Then that is in England, Petition of Rights, 1628, Habeas Corpus Act, Bill of Rights Act, 1689, first to 10 amendments of the US Constitution, then theory of the social contract. What is the basis of democracy? What is the basis of the rule of law? You have to study that is a Rousseau's theory of the social contract. It is not new for the student of the political science. I am not student of the political science. I am a science student. But still, as a student of the constitutional law, I feel that theory of the social contract is very important. Rousseau says that moment man is born, he is a free man. He possesses certain rights, right to liberty, right to equality, right to freedom, right to property. He has got an inherent right in it. And during the course of, that is the administration, government, to run the government, he delegated its rights to his representative. It is some sort of contract between people and his representative. And if the representative failed to take care of the welfare of the people, welfare of the subject, then people have every right to overthrow the government. In that way, there is a contract. That's why it is a basis of democracy. Why we hold election every after 5 years? During 5 years, people examine, review, understand whether the coming government in power, whether their representative has taken care of their welfare, their interests or not. They protect their property or not. They protect their liberty or not. And if they are not satisfied with the performance of the representative, then in election, they throw away that government, defeated that government. There are so many examples. The coming government, that existing government has been thrown away by the people during elections. That's why every year we present the budget. Government present budget to the assembly. Because what is assembly? What is the legislative assembly? This is a representative of the people. Our preamble says that we the people of India. What do you mean that we the people of India? We the people of India denotes the supremacy of the government. Supremacy of not government. Sorry. Supremacy of the people. We the people of India means supreme. Peoples are supreme. Peoples are sovereign. Every power, whatever power may be, it is in the hands of the people only. That's why this that is a people supremacy is laid down in the preamble itself, in the constitution itself, and the assembly, that legislative assembly, Lok Sabha, these are all that denotes the supremacy of the people. That's why the theory of the social contract is very much important, which is a basis of the democracy. One more thing, just I would like to point out, so far as this constitutional teenage mandates is concerned, you have to study the that evolution of Article 14 also. How Article 14 was interpreted by the Supreme Court. Role of the Supreme Court is also very important. What is the principles set down in the preamble? What are their meaning? So that is we the people of India having resolved to constitute India into a sovereign. What is the meaning of the sovereignty? Sovereignty means it's those characters of the constitution. We are not subject to anybody, any other authority, any external authority. We are free to take our own decision. That is the sovereignty. We are free. We are not subject to anybody's powers. Sovereign, socialist. What is the meaning of the socialist? Socialist, this word was added by the 42nd Amendment of the Constitution. So socialist is equality. It is one of the parts of the equality. There is no poor. There is no that is a rich. There should not be a gap between rich and poor. There is sociality. Secular. State should not promote any religion. There is no state religion. Secularism. In S.R. Bommai's case, Supreme Court declared that secularism is a basic structure of the Constitution. The theory of the basic structure also I am going to explain you. Basic structure theory. Secularism. Socialist, secular, democracy. What is democracy? Democracy is a Latin word. Demos, people. The rule of the people. Democracy is the rule of the people. So this democracy, it is a most important characteristics of the Indian Constitution. It is a Latin word, democracy. We have in the world, when we see the democratic government, we have two types of democracies in the world. One is a presidential democracy, others is a parliamentary democracy. In Constituent Assembly, this issue was discussed threadbare. Which type of system do we have which is suitable to our country? Presidential democracy or parliamentary democracy? The constitutional makers, they have studied both systems. In presidential democracy, it is a stable government. Once President of America is elected, it is a non-parliamentary executive. President is not responsible to the popularly elected house. In America, there is two houses, Senate and House of Representatives. President and his cabinet, they are not responsible to the that is a Senate or House of Representatives. That's why Senate or House of Representatives, that is American Congress, cannot remove American president until his term is over. American president recently, as you are all aware, that elections is over, 4 years term. Before 4 years, American president cannot be removed. And American president is not responsible to the American Congress. He is free to take any decision, of course, with certain limitations. That is a presidential democracy. If you are a citizen of America, you can be appointed as a minister of in the president cabinet, and you are not responsible there. President and his cabinet need not have to enter into the Senate and House of Representatives and responsible to answer the questions, calling attention, then other devices, budget, and all those things. Nothing. Presidential system is altogether, it is a non-parliamentary executive, irresponsible executive, but it is a stable executive. Stability is there. So our constitutional makers, they have studied. They thought, do we want a stability or responsibility? And in parliamentary type of government, it is a British system, parliamentary government. In parliamentary system, Council of Ministers or Prime Minister, headed by the Prime Minister or Chief Minister, they are collectively responsible to the popularly elected house, that is Lok Sabha or Vidhan Sabha. Lok Sabha or Vidhan Sabha, they have every right to remove the popular government if they lost majority in the Lok Sabha or Vidhan Sabha. The Council of Ministers, the principal form is that, principal crux of the parliamentary form of government is that Council of Ministers headed by Prime Minister must command a majority in the Lok Sabha or chief minister in the Vidhan Sabha. And moment they lost the majority, they have to resign. At no point of time they can afford to lose the majority in the parliament, and that is the Vidhan Sabha, legislative assembly. This is the crux of parliamentary form of government. It is a responsible government. The Council of Ministers is responsible to the Vidhan Sabha or Lok Sabha, contrary to the American form where president is not responsible. So that's why our constitutional makers deliberately choose the responsible government, because if for this infant democracy, they thought that responsible government is better than the stable government, because they are the responsible government and their responsibility can be assessed. Periodic assessment of the responsibility is there through the legislative assembly or parliamentary session, where the members of the parliament who are direct representative of the people, they ask the government to explain their policies, vote the budget through the committee system. They control over the executive. In that way, that democratic system we have been adopted in the constitution itself, a responsibility. In that type of democracy we have adopted in the constitution. Secularism, democratic, republic. It is not a hereditary one. This is also a very important feature, republic, nature of the constitution. In the king, the son of the king is put on the throne. It is not in democratic system. It is a republic, chosen republic person. Our president is indirectly chosen. Our president cannot be compared with the American president. That is a republic government. So this is ethos and characters of the Indian constitution, that is a justice. Three kinds of justice. It is ensured in the preamble: social justice, economic justice, political justice. What do you mean by the social justice? Socio-economic justice. It is a very important features of the Indian constitution. Social justice, that is the welfare of the common man, welfare of the people. For that purpose, directive principles of the state policy is very important. You have to study the provisions of the directive principle of the state policies. That is the welfare of the people. All this welfare of the people, various schemes enacted by the government, various schemes implemented by the government. It is for the welfare of the people. We can thousands of examples for the that is the schemes enacted by the government for the welfare of the people. It is the social justice, socio-economic justice. It is the aim of the government, aim of the administration, aim of the elected government to ensure the economic justice. Economic justice, that their condition should be good. All economic policies should aim towards the welfare of the people. Social justice, economic justice, political justice, one man, one vote. Very important principles. I pointed out. I would like to point out that moment our constitution came into force, one man, one vote principles was implemented in the provision was made in the constitution. In England, the women has to fought so many years, where we say that it is a 800-year democracy. We have visited House of Commons, House of Lords. There are so many of their traditions are followed in the Britain. There the women has to fought for the voting right till 1920. America, same condition. In so many countries, still women have no voting right. See the majesty of our constitution. One man, one vote, political democracy. Anybody can contest election. Anybody can become a member of parliament. Anybody can become of course, criteria has to be fulfilled. Representation of the people and provision of the constitution has to be fulfilled. So that is a political democracy. What a great provision made by our constitutional makers. Political democracy, social democracy, political democracy, economic democracy, liberty. What is liberty? Article 21. No person shall be deprived of his life and personal liberty except according to procedure established by law. This is a very important 2 lines only. Thousands of decisions has been given by the Supreme Court on the liberty. Recently, I'll come to the Arnav Goswami's case. You may not agree with this. Some may not agree. But liberty has to be protected by anybody. During this lockdown period, we are in the house. That time we experienced what the importance of the liberty, how our liberty is important. We cannot move out to our, that is outside our residence. So liberty is very important. Unless for the breach of law, you cannot be arrested. Your liberty cannot be taken away by the government, by the police, by the anybody. So Article 21 is very important. Your liberty is very important. Your independence is very important. And this is guaranteed in the Constitution. Liberty, equality, liberty, it is guaranteed in the Constitution. Liberty of status and of opportunity, and to promote among them our fraternity. We are all one. Indians are one. Equality. Equality is the most important principle. Just now I explained. Equality before law, equal protection of the law. Whenever there are so many decisions, Supreme Court has developed this concept of the equality. That is a due concept of equality. Supreme Court has evolved. That Article 14, states shall not deny to any person equality before law or equal protection of the law. And this concept is very important. And Supreme Court has developed, role of the Supreme Court is very, that is a judicious role. Judicial revolution you may call it as. Supreme Court in so many cases that develop the concept of the equality, new concept of equality, Article 14, they have given new meaning, protection against arbitrariness. Whenever there is arbitrary action, it is a denial of the equality. Arbitrariness is a sworn enemy of the equality. Arbitrariness and equality cannot live together. Whenever there is arbitrary action, any citizen is that is experienced arbitrary action on the part of the government, on the part of the administration, and if he is ready to prove in the court of law, then such action can be struck down by the Supreme Court under Article 32 of the Constitution or under Article 226 of the Constitution. So equality, liberty, fraternity, sovereignty, secularism, these are the most important principles laid down in the Constitution itself, preamble itself, that protection against arbitrariness. Particularly, I would like to point out E.P. Rayappa's case versus Tamil Nadu 1974 judgment. Supreme Court drifted from the traditional concept of the equality, which was based on the reasonable classification, and laid down the new concept to the equality and declared that equality is a dynamic concept with many aspects and dimensions. It cannot be cabined and confined within the traditional and doctrine's limits. So equality is a very dynamic concept, and activist judges like Justice Chandrachud, Justice Krishna Iyer, and Justice Bhagwati, they have given the new dimension to the that is concept of the equality. And in so many cases, E.P. Rayappa, Maneka Gandhi's case, then Airport Authority's case, D.S. Nakara's case, Nargis Mirza's case, a lot of cases, they have declared a new jurisprudence to the Constitution, and they have given a new meaning to the Constitution. Really, we are thankful to the role of the Supreme Court, so far as there is activist role Supreme Court has played, so far as interpreting Article 21, life and personal liberty, and Article 14, that is equality. Now, what is included in the life? Your dignity is included in the life. That that is welfare is included in the life. Complete environmental jurisprudence, educational jurisprudence is based on the decision given by the Supreme Court in Maneka Gandhi's case. I will just point out the case of the A.K. Gopalan's case. It's a very old case, 1950s case, where Supreme Court has narrowly interpreted Article 21 of the Constitution, which ensures life and personal liberty, where Supreme Court says that law is only a state-made law, no principle of natural justice, no just, fair, and reasonable law. But the concept of natural justice within a span of, it took 30 years by the Supreme Court, where so many cases are there. And ultimately, in Maneka Gandhi's case, Supreme Court has introduced the concept of natural justice and says that law must be fair, just, and reasonable. Only state-made law is not during emergency period also. ADM versus Jabalpur. The Supreme Court has given a very erroneous judgment, very wrong judgment. But in Maneka Gandhi's case in 1978, Supreme Court Justice Chandrachud, Justice Bhagwati, they have introduced a new concept, new development to the principle of natural justice and concept of natural justice and concept of due process. Ultimately, it was introduced. While making constitution, our constitutional makers felt that concept of due process should be part of our constitution. But that time, the constitutional makers felt that just I am taking a little time, 5 or 10 minutes. The concept of natural justice was that it should be just, fair, and reasonable. And ultimately, in 1978, the concept of due process was part of our constitution. These are the very important principles that natural justice was introduced, and in that way, now the people get the tools of the public interest litigation. So many public interest PIL, public interest litigations are now being filed, and people get the justice. Writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto. So many writs under Article 13, under Article 32, under Article 226. That is a judicial review. Very important feature. Equally, as per rule of law, judicial reviews are also a very important, that is ethos and character of the characteristic salient feature of the Constitution. Judicial review, because our judiciary has been given power to struck down any piece of legislation or administrative action which violates the provision of the Constitution. Of course, Constitution is supreme law of the land, organic law of the land. No law, rules, regulation, bylaws can violate the provision of the Constitution. Supreme Court is protector and guarantor of the fundamental rights and provisions of the Constitution. That is, a judicial review is a basic structure of our Constitution. And in Keshwananda Bharati's case, the Supreme Court has evolved, Minerva Mills case, the novel feature of the basic feature of the Constitution. And Supreme Court has declared that, rules that Parliament has no power under Article 368 of the Constitution to amend it so as to take down the basic feature of the Constitution. And ultimately, in 99th Constitutional Amendment, the Supreme Court has struck down the constitutional amendment passed by the Parliament by 2/3 majority and assented to by the 50% states as per Article 368 of the Constitution. And concept of the judicial review is very important concept which has been given by Supreme Court. And this concept we have inherited from the very famous American John Marshall judgment in Marbury versus Madison, 1803. It's a very important landmark judgment where first time American Federal Court has declared that the Supreme Court, Federal Court has power to struck down the piece of the legislation made by the Congress when it violates that is a constitutional provision. So that is a concept of the judicial review. This is also a very important concept, and in that case, the liberty, equality, fraternity, judicial review, parliamentary democracy, federal nature. One more point I would our Constitution is quasi-federal. It is neither federal, neither federal features. Our Constitution is federal. We have three lists in the Constitution: distribution of powers, dual government, distribution of powers, authority of court, supremacy of the Constitution. These are very important federal nature which we have been inherited from the American one. So federal features is also a very important, that is a characteristic ethos of the Constitution. All that is a three lists are there under Article 246. The powers are divided: central list, that is a union list, state list, concurrent list. In union list, we have 97 subjects. In state list, we have 66 subjects. In concurrent list, we have 46 subjects. All subjects have been nicely divided. And there is a that legality, or it is a rigidity is avoided in our Constitution. It is a majesty of our Constitution is that the rigidity completely avoided by dividing that complete powers between the union government, state government, and some important subjects like your education is in that is the NT25 environment. It is a part of concurrent list. Both state and union parliament can make laws on such subjects. Of course, the cardinal principle is that subjects those are of national importance. It comes under the purview of the union parliament. Subjects those are of state importance like police, law and order. Comes within the purview of the state government. But subjects those are of national as well as state importance like marriage, criminal procedure code, civil procedure code, education, environment. They come within the purview of the concurrent list. So on the union list, only union parliament can make law. On the state list, state government can make law. And as far as concurrent list is concerned, only the union and state both can make law. The principle is that only if there is a conflict, controversy between union law and state law, always union law prevails. These are certain, that is a basic feature of the constitution. In Keshwananda Bharati's case, Supreme Court laid down very important principle is that the constitution has, right from the Bihar versus Kameshwar, Sajan Singh case, the Shankari Prasad case, Golaknath case, Keshwananda Bharati's case, that is a Rajaram Pal case, that 99 constitutional amendment case, when Supreme Court has developed the constitutional jurisprudence and they put the limitation on the power of the parliament, limitations on the power of the legislature. They thought that the parliament should not misuse their power. This concept of the rule of law should be upheld. Constitution should be upheld. Parliament by their brute majority, two-third majority, constitution should not be destroyed. The principles, basic principles of the constitution should not be destroyed. That's why in Keshwananda Bharati's case, they have laid down the very important, that is the principle of basic feature of the constitution. In that way, they have kept the control over the power of the legislation in Keshwananda Bharati's case. And that's a very important features of the ethos of the characteristics of the constitution. I think I have crossed my, that is a 5-10 minutes I have taken. I'll take 5-10 minutes more. In Arnav Goswami's bail case, you may not agree with this case, but in that case, Supreme Court, particularly Justice Dhananjay Chandrachud, very informative, very nice judge, very informative, very clever and studied, knowledgeable judge. Personal liberty has declared that personal liberty must be protected and upheld. You may not agree with the ideas, you may not agree with the ideology with the Arnav Goswami, but you should not overpower them. You should not misuse that power. High Court in error in rejecting this application for the bail. If the court does not interfere today, we are traveling on a path of destruction. Forget this man. You may not take his ideology if this is what our state government is doing. In that way, the role of the Supreme Court, rule of law, it is the role of the Supreme Court to uphold the rule of law, judicial activism. Then all this in Vikas Dubey's case, Supreme Court reminded the that is the UP government to uphold the rule of law and inquire about the encounter of the Vikas Dubey. You may have a different opinion, other may have a different opinion, but there must be a that is a respect to the constitutional tenet, constitutional ethos, constitutional character. Constitutionalism has to be upheld by everybody. It is a duty of the Indian citizen, a duty of everybody to have just to uphold the principles. And last 2-3 minutes I'll take, because good governance, it is everybody's right, and in that way that the constitution has given so many things to you, and in that thing you have to protect those things. Parliamentary system, secularism, that is a liberty, equality, but we have so many problems. That is a slow administration. Everybody, I just put so many problems before you, because while upholding the constitution, Supreme Court should be accessible. It is not easy to move the Supreme Court. Will of the law has to be moved. Law suo motu doesn't take cognizance of anything. I earnestly point out. And to go to the Supreme Courts and High Courts is not an easy thing. Common man, is very difficult for the common man to go to the Supreme Court and High Court. So that's why it is my humble suggestion to all of you, all my learned professors, learned principals, all my learned friends, we must have some benches of the Supreme Court in state also. That also idea I also always mooted before bar, before bench, before colleges. Supreme Court must have benches at the local level, in state level, so that the common person, if the justice is away from the common person, what is the use of all this provision of teaching you? Just liberty, equality, fraternity, with principles of preamble, social justice, economic justice. What is the use then? It is just that ornaments in the book. Rule of law. How you implement the rule of law? Rule of law is nowadays casualty. Everybody that is a state administration, lot of that is a nepotism, arbitrary actions of the on the part of the state machinery, arbitrary actions on the part of the state government, state department, slow administration. Need for strong control on the administration. We need a need for the strong control. Educational system. There should be an improvement in the educational system. Educational system should be should cater the need of the person. It should not be only a degree on the that is which are hang on the wall. It should cater the need of the person. Education must be such that it takes some money. Then only that education system carries certain meaning at all. You have to all this learned person. My earnest request is that this system should be at least some changes should be brought in this education system. One more thing, I am really very much concerned. Merit is everywhere is ignored. Meritorious students, meritorious persons everywhere, not only in the government, but even in the private sector, corporate sector. Nepotism, favoritism. It is everywhere. It is there. So that aspect has to be taken care of. Then unemployment problem is there before the country. That corruption, big problem of corruption is before the country. These are all problems I just put before you by this occasion. I am really thankful to I have taken more time. I am really thankful to the organizer, my respected principals, all my professors, all my students, those who have given me very patient hearing and I am really honored by this prestigious institute who is imparting the quality education in the city of Mumbai. And thank you very much for
all.
Thank
Thank you very much,
you,
sir. Honestly speaking, it is very difficult to speak about the Constitution, its ethos and values in such a limited time. But I must admit that your speech was very well researched. There were lots of inputs. You talk about the Dicey, Blackstone, you give the background of the rule of law from British Parliament. And then also you touch upon the Arnav Goswami case, which was very recently came in the newspaper and it was highly debated and discussed. So almost all the important aspect of the Constitution is covered in your speech. On behalf of our institution, I thank you from my heart that definitely our student will take away forward whatever you have mentioned in this your very precise and very enriching lecture. You mentioned about lots of cases. I'm sure that students of political science especially, they will read about more these cases and will try to understand from these cases. Just in one line, if I would allow to sum up this particular session, I would like to say that eternal vigilance is the price of the liberty. Okay, this is the message we need to carry forward on this occasion of the Constitution Day. Sir, and with the permission of the Cursis sir and permission of the Dr. Rajwade sir, if there are any questions from the side of the students, can we take few questions, 1 or 2 questions?
Yes, sir, no problem.
Yeah, thank you, sir. Even the teachers who have joined this session or anybody is free, this forum is now open for the question answer. I requested already to put your question in the chat box, but I'm unable to see any question. But apart from that, if you have any query, if you want to ask something more to Kalsi sir, please be free. You can unmute yourself and ask.
Sir, I have a question.
Yeah.
Sir, in news I am reading about the bad situation in West Bengal, and
Hello. Please mention your name, class,
yes,
identify yourself.
yes. So my name is Aditya Mishra, and I am from Ratnam NES Ratnam College FYBA student. My question is that, sir, I am reading news about the bad situation in West Bengal, and there are many criminal activities there. So I was thinking, why didn't president has enforced the emergency till now there?
No emergency, that is it is an undemocratic thing. Dr. Ambedkar, that time in Constituent Assembly, he has specifically declared that Article 356, Article 352, Article 360, that emergency provisions, they are the dead letter. They should be dead letter. It is very difficult, and nowadays during that previous government, so many times emergency was imposed, and legally elected government was coupled by the respective government. You know the example of 1977, 1980. I'll not go to the details. And now the Supreme Court has given a specific ruling in S.R. Momoi's case to impose emergency, the cabinet, and they have put a specific limitation on the part of the cabinet and government, and there they put a rider to impose the emergency. Nowadays, it is very difficult to impose the emergency, and we have to satisfy it is a justiciable issue. Supreme Court can examine such type of issues. Legally elected government cannot be overcome, cannot be toppled, cannot be destroyed by political process. So that's why this is in West Bengal, to my mind, it is a legally elected government, and to claim the emergency or to impose the emergency under Article 356, it is a very difficult, and it is a justiciable issue, and President has to think 100 times before issuing the order, and Cabinet has to think 100 times Union Cabinet to issue the order. It is not a very easy thing nowadays to impose the emergency.
Thank you, sir.
Okay, sir. Thank you, sir.
Thank you. We'll take only one more question. Only one more question, because already we are running out of time.
Yes, sir. Can I ask?
Yeah.
Yeah, sir. This is FYBA student Swaraj Manekar of Sathe College. Obviously, political science student. And my question to you, sir, is Prime Minister of India today addressed on the occasion of Constitutional Day, and in that speech he mentioned that he calls for simplified language of law. So, what is your view on that?
No, simplified language of law, it is okay, but there should not be a ambiguity in the law. Simplification doesn't mean that law should be interpreted, because the language of the law should be very specific. We are drafting the law. If we simplify those provisions, and if in that way there is a lot of interpretations, advocates, courts, they interpret the law, and if the simplification carries there is a misinterpretation of the law, then court will fill the gap, and court will suggest. In so many cases, the court has suggested the new provision of the law, amend the law. Of course, court has no power. You have three wings of the government: legislature, executive, and judiciary. It is a specifically power of the legislature to draft the law, to prepare the law, to make the law. It is nothing, but court can suggest certain that is a improvement in the law, particularly Vishakha judgment, domestic violence case, such type of cases, such type of suggestions, T.K. Basu's case, such type of suggestion has been given by the court, and on that basis, Parliament enacted the law. Simplification of law, I have no objection, but it should be very specific. The meaning should be one only. It should not be a double meaning. It should not be a multiple meaning. Otherwise, it will become a chaos and become a lawless society. So that care has to be taken while simplifying the law.
Thank you, sir.
Oh, thank you, sir. I know that there might be lots of questions in the minds of the students, but dear students, we have a paucity of time. So I again thank you, Dr. Kalse sir, for answering the queries of our students. Thank you very much. May I now request the student of our Department of Political Science, Yashasri Rane, to propose a formal vote of thanks, and the program will, after that the program will conclude with the national anthem. Okay, over to Yashasri.
Thank you so much, sir. Hello, everyone. At the end of this program, now I propose a vote of thanks. Thank you so much, Kalsi sir, for such eloquent lecture on the sacred day of 26th November, on which our constitution was adopted by the Constituent Assembly. The democratic India stands firmly on constitution and the foundation of the principle of constitution. It's really helps us. Information shared by Sir is valuable to every citizen of India, and vast knowledge and experience of Sir made his speech insightful and useful for all of us. Thank you so much, Sir, once again. I now thank our principal, Sir, for giving us this opportunity to organize this lecture. I thank our vice principal, Sir, for supporting us. I thank all our distinguished invitee guests and professor for their gracious attendance. My special thanks due to our NSS degree and junior team for their collaboration with us. I thank our faculty members of Political Science Department for putting in effort to organize this program. I thank our technical team for their invaluable support. Last but the most important, I thank all the students audience. Without his presence, this program will not have been successful. I thank all my student friends for their enthusiastic presence. Now there will be the national anthem, and then the program is over.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you so much, everyone. Now the program is over now.
Thank you, Kalse sir.